2020 Lincoln County Planning Commission meeting. At this time, would Joshua call the roll call, please?
Andra Bobbitt.
Here.
Terry Bugenhagen.
Here.
Shaylin Stratton.
Here.
Judy Pelletier.
Here.
Phil Spolnick. Dick Cutler.
Here.
Scarlett Kerr.
I'm here.
And Misty Lambrick.
Here.
Thank you.
Okay. Do we have any past action review for the Planning Commission?
Because it's been so long that we've met, it would take almost a year's worth of stuff to share with you. So I'm going to keep that exceedingly brief tonight, other than, again, just thank you for our first meeting in a very, very long period of time. And just one note, Madam Chair, Andrea, you and I had said earlier, let's make a point of not talking about the upcoming hearing on the 23rd. It really isn't appropriate because of quorum issues. So if anybody wants to engage in a discussion about that, please do it offline with staff, not among yourselves, but with staff. And so why don't we just go into the Madam Chair, I would suggest we ask our three new colleagues to introduce themselves. And so does anyone want to go first? Misty or Scarlett or Shaylin? Anybody eager to explain who you are and why you committed yourself to this process?
Yeah. Make it. Sorry.
Go ahead.
Okay. I'm Shaylin Stratton. I've lived in the county for about 10 years, minus a few months that I spent in St. Croix, U.S. Virgin Islands, about 5 years ago. I have about 14 years experience as a land use planner and environmental analyst for a variety of departments in California. Moved up here after I retired and worked with both NEPA and CEQA in California and California Environmental Quality Act, evaluate county projects, major county projects. I was a senior planner in Calaveras County in California and evaluated the projects and such from all kinds of different projects, easy ones, hard ones. And then I worked for the California Energy Commission and the Parks and Recreation as an evaluator for environmental impacts in land use, transportation, and aesthetics under the California Environmental Quality Act and under NEPA. And I'm married, have been for almost 25 years now, and I live in Glen Eden Beach.
Thank you.
Welcome.
Thank you. Yes, welcome.
Next, Scarlett for Misty.
I'll go. I'm Misty Lambrecht. I've lived in the county 20 years. I recently purchased property in Siletz, Oregon. I lived in Eddyville and in Toledo, but all in the county. I have an electrical engineering degree. I work for the Oregon Coast Community College as a small business consultant. And I got involved just because I've been through quite a few land buys, house buys, things like that. And I've consulted businesses on purchases of land and buildings and things. And I just thought it was a good fit.
Welcome. All right, Scarlett.
I'm Scarlett Keir. I moved to Lincoln County in 1982, got my real estate license in 1991. That's a little bit about how old I am, I'm afraid. Started working real estate with Doug Roberts back in 1991, and some of you will know of Doug and some of you won't. And then we branched off, I want to say maybe 20 years ago, and I've been with Advantage Real Estate ever since then. I like to comment that she's done a few real estate transactions. I've done a couple. So I'm in and out of the planning office on a pretty regular basis when we can get into the planning office. I'm probably just curious, you know, expand my knowledge of process. That's probably it. So, and I didn't meet everybody and work with everybody. And I've worked with Matt. Matt, hi.
Great. Well, welcome. It's good to have a fuller deck, and I have to say it's good to see a lot of female faces. So there you go. A little bit of a bias there, but we'll go over bias in a moment, I'm sure, on all those slides. All right. So Matt and Jerry, you ready to take it away then?
We're ready. I think that Matt's going to go ahead and get us started.
So Josh,
Yeah.
can you load that PowerPoint for us?
Yep, 1 second here.
I don't think you need an introduction, Matt, but maybe you just might say where you're coming from for anyone who might not know.
I'll do that. So yeah, great to see at least a few familiar faces, but for those of you who I haven't met, my name is Matt Spangler. Let's see, just a quick little bit about my background. So I've been working as a land use planner here in Oregon for more years than I will admit to, because that would reveal my rapidly advancing age. Started as a planner, working as a planner here in Lincoln County, worked here for several years, went off to Portland for a brief stint before I came to my senses and returned to the coast, and been basically here ever since. Spent some time in sitting behind Anno's desk as the department director. And then in late 2000, I think it was in 2009, I moved to the state of Oregon, Department of Land Conservation and Development, worked for the department in the coastal management program there for about 10 years. A couple years ago, then I retired from full-time work, but I'm doing a little part-time contract work for the county. So that's what brings me here tonight.
Thank you.
So Jerry and I are going to kind of tag team this presentation. And so I'm going to get started here with, and what we're going to talk about tonight is kind of just the basic hearing and decision-making process. And this will be sort of old news to some of you, but probably a good refresher for all of us occasionally to kind of walk through this stuff. So can I get that first slide, please, Josh? I guess it's the second slide technically. So when we talk about land use decisions, in particular under Oregon law, we're really talking about three basic types of decisions. There's the legislative decision, which is basically, as the slide indicates, is making law. So that's kind of the policy stuff. There's quasi-judicial decisions, which involve applying and interpreting law in a manner that under Oregon law, land use decision means that it's a discretionary kind of decision. And then the third type, which really wouldn't concern folks here, is the ministerial decision, which is the routine stuff that your staff does on kind of a day-to-day basis, reviewing building permits, signing off on septic permits, that sort of stuff. Next slide, please. So again, the distinction between legislative and quasi-judicial decisions is an important one for a whole bunch of reasons, but especially in terms of the procedure by which those decisions get made. So again, a legislative decision is a process whereby the county is adopting new policies or new law. So think about adopting new policies in the comprehensive plan, for example, that have general county-wide application. Probably the most common stuff that you're going to see on the legislative side of things would be amendments to the development code. So the land use regulation portion of the county code, that's a legislative decision. And the planning commission's role in legislative decisions, of course, is to make recommendations to the board of county commissioners, because those legislative acts have to be enacted typically by ordinance. And so the board has the authority to do that, but they take input from the planning commission and through a public hearing process typically. Probably the majority of the stuff that you're going to see in front of you are the quasi-judicial land use decisions. And so quasi-judicial is sort of one of our planners' $5 words for basically a judicial-like process. So a quasi-judicial decision by definition is sort of a fact-finding exercise. Probably the most common stuff that you're going to see in front of you are going to fall into this category of quasi-judicial, and that's mostly what we're going to talk about tonight, because that's the kind of stuff where there's some fairly rigorous and strict procedural guidelines, and there's due process requirements and so forth for quasi-judicial. So between Jerry and I, we'll try to cover all those things tonight. But the typical garden variety land use applications, conditional use permits, variances, subdivisions, partitions, zone change applications, that those all would come before you as a quasi-judicial type of decision. Next slide, please. So again, the quasi-judicial decisions have the characteristic of having these due process requirements, what us land use nerds here in Oregon refer to as the Fasano requirements. And what Fasano means is, that's the title. It was actually Fasano versus Washington County Commissioners, a famous land use case here in Oregon dating back to God, even before my time. It was like right after the earth cooled. And what happened in Fasano in short was that there was an application to Washington County for a change in zoning, and it was an individual piece of property change in the zoning map. And the Washington County Commission had for years treated these things as if they were legislative in nature. In other words, they were policy making. They could just kind of do whatever they wanted with these types of applications in terms of the multitude of policy choices in front of them. And that case eventually wound its way up to the Oregon Supreme Court, and the Oregon Supreme Court said, no, it's if you're adjudicating an application for an individual piece of property and an individual specific type of land use authorization, that's not legislative. You don't have free reign there. That is quasi-judicial, and that's a fact-finding exercise that requires due process. So, and those due process specifications that the court laid out were opportunity to be heard, opportunity to present and rebut evidence, an impartial tribunal, which that's you, that's you all, and Jerry's going to cover a lot of that stuff about as far as what that means. And the parties are entitled to a record of the proceedings. In other words, there's a fixed record of evidence that is gathered and then relied upon by a decision maker. And then finally, the decision has to be supported by findings that are adequate to explain the reasoning behind how that decision was arrived at. Next slide, please. Oh, yeah, this one. Jerry, you're going to have to take this one now.
Okay. I think we need to go to the next one now.
Okay, all right. So the due process typically involves this these steps, and it's sort of how an application finds its way in front of a decision-making body like the Planning Commission. So somebody shows up at the Planning Department office, they file an application for a particular authorization or approval. The staff determines what the criteria are in the land use code that apply to that application. In other words, what are the standards for making a decision on yay or nay on a particular application. Staff would then provide notice to the parties, and that's all specified in Oregon statute. So notice goes out, a mailed notice goes out to parties as well as surrounding area property owners. Your staff will prepare a staff report for you that'll sort of detail the proposal and how it lines up with the applicable criteria. And at that point, then it lands in front of you all for a public hearing process. And that public hearing process is for the purpose of submitting evidence. Parties get to testify, submit and rebut evidence into the record. And then once that record is closed and the hearing is concluded, then the Planning Commission would deliberate and make a decision. Typically after an initial oral decision by the Planning Commission, then there'd be preparation of findings, and ultimately then those findings would get noticed to parties to the case, and they'd have an opportunity to appeal that decision. Next slide, please, Josh. So the key statutes are, you don't need to remember this. This is, your staff needs to memorize these, but you don't. So ORS 197-763, which basically codifies all of the conduct requirements for quasi-judicial land use hearings, and then ORS 215-416, which is specific to counties and specifies sort of the procedures for different kinds of decision making. Next slide, please. So the application is basically, it's a process where folks kind of go through a kind of a prescribed process to actually trigger the decision-making process. Usually that'll start with, it's a fairly significant kind of application, it'll start with a pre-application conference with the staff. The applicants come in, sit down, talk to staff, figure out, okay, what are the issues here? What are the criteria? What kinds of stuff do we need to support the proposal that we're making? Hopefully that kind of homework gets done prior to the actual application coming in. Once the application comes in, then there's this sort of strange iterative process under Oregon law, but the bottom line is the staff has the first shot at it. They can determine whether or not the application is complete based on our local requirements for completeness. If it's not complete, then they notify the applicant to that effect. And at that point, then the applicant has the option of either submitting the requested information to complete the application, or they can say, you know, we're not going to submit that. We think our application is good right now, and we choose to proceed. And at that point, then the application is deemed complete, and the decision-making clock starts. And for counties, in most cases, that decision-making clock is 150 days. So if you hear your staff talking to you in hearings about procedural issues related to the time clock, that's what they're talking about. Is there's a statutory limitation for completing a final local decision within that 150-day period. Next slide, please. So approval criteria are those standards and provisions typically in the land use code that are going to be applied to a particular request. In other words, that's basically, those are the measuring sticks by which the decision-making body, in this case the Planning Commission, determines whether or not an application is a go or a no-go. Occasionally they might involve policies in the comprehensive plan, but for the most part in Lincoln County, that's not the case. County's done a good job over the years of, in an ideal world, all of the more general policy stuff in the comprehensive plan would have corresponding implementing regulations in the code that are more specific. And that's generally true here in the county. The county's done a good job over the years of mostly having their implementing regulations pretty well squared away in terms of alignment with their plan policy. Once in a while, you may have a plan policy that comes into play, but not very often. So always the basic question in front of the commission in one of these quasi-judicial proceedings is, does the application satisfy these applicable criteria that are identified in the hearing notice and also spelled out and discussed in the staff report? If it fails to satisfy those, then of course the application fails and it has to be denied. But occasionally you'll find an application where the approval criteria, it's judged that they can be met through the imposition of certain kinds of specific performance requirements on an applicant. So for example, if you have an application where maybe visual impact is an issue with surrounding property owners, a condition that requires site obscuring barriers or other kinds of things that might mitigate that impact, then could render the application compliant with that requirement. So that would be typically an example of how a condition might be used to satisfy approval criteria. And Jerry and I you'll probably find us continuing to harp on this last point, but when a quasi-judicial application is before you, the decision really has to be based only on the specified criteria that are set forth in the code. Sometimes there's a temptation to want to look beyond that, and you'll often hear that from folks who are testifying in hearings, trying to get the commission to look at other issues, but really in the quasi-judicial setting, you're limited to really considering the applicable criteria that are contained in the code. All right, Jerry, I'm going to hand it off to you.
Thank you. Next slide. I think that's a pretty good one. Anyway, Andrew, if it's okay with you, I'm just going to introduce myself briefly, as not everybody probably knows me. I'm Jerry Herbage, and I'm happy to be here tonight. Have a chance to talk to you just like Matt has. By way of background, I'm from Roseburg, but went to Oregon State and U of O for law school. Following graduation, I took a job in Gold Beach for Curry County in 1981 and ended up working for Curry County for some 34 plus years. And I've worked for Lincoln County since May of 2016. When I worked in Curry County, I started out as a deputy district attorney, but most of the time was spent as the county counsel. And so I've been doing land use for a long time, although land use among a million other things and not necessarily specialized. Okay, let's go to the next slide. So these are very important concepts. And so evidence, it gives you a description, but you know, it could be maps, could be compilations of data, materials, facts that the applicant has submitted or that the other parties have submitted. But it's the kind of thing that to show compliance or non-compliance with the criteria. So you have that, and it's important to distinguish that from argument. So as I told you, I had been a prosecutor in a different life, and you're all familiar with the courtroom, and we could compare the quasi-judicial to the judicial, and there are many similarities, some differences. But you know, after all the evidence is presented, then you have argument and final argument, right? And at that time, you're not allowed to bring up new evidence, introduce new things to the jury. Argument to me really means my side should win because, and then that's the argument. So, and understand that under ORS 197-763, which Matt had brought up earlier, the applicant, because the applicant has the burden of proof, has the right to submit final written argument, and in the 777, those are days formula that we have. We'll probably talk about that later. This talks about testimony. Testimony can be written or oral, and all this stuff that's in, like the evidence and the arguments, testimony, and so on, is in the record if it's submitted to the decision makers. This is an important concept as well, because understand this, that many land use matters get appealed. And if it gets appealed to the Board of Commissioners, the next level, generally the board will decide the case on the record, meaning you better have had your stuff in. That this is to any applicant or anybody out there. They better have had their stuff before you, the Planning Commission, if they want it to be considered. And then when it goes to the Land Use Board of Appeals, which is the next level, well, they're gonna, Land Use Board of Appeals will decide the matter on the record. And so it's not like a new hearing. And so let's go to the next slide. Substantial evidence. So you can go ahead and read that definition. This is based on case law, and it is evidence a reasonable person would rely upon in making a decision. And I can tell you that, and I think you know this as well, that if you go to a court proceeding, let's say it's a criminal trial, the standard is you have to prove the defendant guilty beyond a reasonable doubt. That's a strong standard. That is really a high standard. And when I was a deputy DA, we also did some civil commitments. And if someone, and these are mental commitment proceedings, and if someone's to be committed, it's based on clear and convincing evidence. That's a pretty strong standard too, not as strong as beyond a reasonable doubt. But this standard is really interesting. It's different. It's evidence a reasonable person would rely on in making a decision. And you could have a case where there is some dispute and there are experts from both sides, and it may very well be that you could make a decision either way. A reasonable person could rely on either expert and the evidence. So anyway, that's the standard. And remember, the applicant has the burden of proof. Okay, next slide, please. Notice. So Matt indicated very correctly that we're all under Fasano standards, meaning due process. And part of due process is notice, so that interested persons may be able to attend these proceedings. And notice listed here is what we would call owner of record notice, and that goes to people in the immediate area where the application applies to. But there's other notice too. Every once in a while you will do a proceeding that involves an ordinance, and if it involves an ordinance, it will be published in the paper as well, at least 10 days before the initial hearing. And this owner of record notice needs to be mailed out at least 20 days before the hearing. And we also have to comply by the public meetings law, just meaning in general that these are open meetings, and notice this to be given to people who would be reasonably interested. Okay, next please. Review by staff. So I think most of you know, and most of you have been here and done this before, but a very critical aspect of these proceedings is the staff report. That takes a lot of work. And but the staff report has to be available at least 7 days before the public hearing. And to the public, available at no cost and provided at reasonable cost. So you will have the staff report. It's important that you be aware of the criteria and the materials that are submitted. Next slide, please. Oh, that's gross. Who put that one in there? Okay, next slide. The public hearing. So ORS 197-763 has a protocol for all proceedings. And part of that is that it'll be the chair, Ms. Bobbitt, will indicate the approval criteria and explain that testimony has to be directed toward the criteria, and that there are penalties for failure to raise an issue, and that's basically you've got to raise an issue or it is waived, meaning it can't be considered on appeal. And that is an extremely important land use concept, because many, many cases go before the Land Use Board of Appeals. And one of the basic elements is, okay, they can raise whatever they want, but not successfully if it didn't get raised at the decision makers level. And the reason is that if there is a problem, you have the right to address it. But if they don't raise it, you might not know what the problem is. Next slide, please. So the chair is going to call for these three concepts, and they're all different. They're all different, but this should be raised. So the chair will say, do any of you have ex parte contacts? Do any of you have bias? And do any of you have actual or potential conflicts of interest? And I think there are slides that follow where we'll go over these concepts. Next slide, please. So there is an order of procedure. Typically, staff will give the staff report, and then the applicant will go next, because the applicant has the burden of proof. So they outline their facts and arguments or whatever, and then the proponents usually next, and then opponents and maybe other interested persons. And Fasano would say that the applicant has the right to rebuttal, and that's listed there as well. Now, one thing I want everybody to know is that we're going to have an electronic hearing on the 23rd. And because of that, the procedure will be slightly modified. The concepts are the same. The procedure will be slightly modified. I think when we're done with this, Matt and I will probably go over the procedure for the 23rd. Okay, next. Oh, man.
Oh,
Okay, next. Okay, ex parte. It's a Latin term, from one part or one side. So it's a one-sided communication between a decision maker and some other person outside the public review. So let's talk about what that means. And it can come in different forms. And so, for instance, remember the concept is like court. So what you're to base your decision on is what is produced on the record in front of everyone, right? It could be written material, it could be oral, but the point is that everyone has a chance to hear it, see it, respond to it. But if it's ex parte, they don't. So an example would be if a decision maker, one of you planning commission members, were to talk to the applicant or another party outside of the proceeding and try to gather, and you gather some additional information and so on. So that would be not good because it's not based on the record. One thing that I see frequently is that we'll have a proceeding and someone will say, well, I went to the site, and this is during the deliberation, it comes up. And, I really don't think this thing should be approved because I observed this, and that. Well, we don't want to do that. A site visit that isn't part of the proceeding is a concern. And it could be a procedural defect that would cause some grief later on. Okay, next.
Jerry, don't you think that's pretty counterintuitive though, right? Because we almost always benefit from visiting a site, but it does constitute an ex parte communication. So
it's in the nature of that. Another example of something in the nature of an ex parte contact might even be reading a newspaper article that has some additional information about the proceeding, because that's not in the record. And yeah, it may seem counterproductive productive. But if collectively, there is a way to do that. If collectively the planning commission feels that like a site visit would be a good idea, it can be arranged. And generally the planning commission members all go there, and you have ground rules. Interested persons can be there, and you have some ground rules about how questions are handled and so on.
And it's properly noticed because of quorum.
Yeah. Properly noticed. You can notice it at the hearing, so that the theory is if someone was interested, they'd be at the hearing, and so like that. So here's the point. Ex-parte contacts on their own they sometimes happen even if you try not to have them, and we would say they can be cured, or the problem can be remedied if it's disclosed at the meeting before the record's closed, and that people would have the right to ask you questions about your ex-parte contact. So ex-parte contacts are correctable if they're announced, but you got to announce it. So we don't want to hear someone going into deliberation when the record's already been closed and say, well, I went there and I saw all this stuff, and I just don't think it should be approved based on what I saw. Nobody had the right to ask you questions about it, so on and so forth. So that's a problem. Okay, next. It says opportunity for rebuttal, and the law we already went through these. So let's go over an important other concept. The concept is this. You as planning commissioners cannot talk to the parties outside of the proceeding and so on, but you can ask questions of staff, the planning staff and your attorney, and we can answer your questions. You might have questions. Do you think this is a conflict of interest, or do you think maybe you have a question about the law or some such thing, and we can help you with that. We cannot introduce new evidence to you, but from the sort of legal standpoint, we can help you with your questions, and that is not ex parte. Okay, next.
And therefore it also doesn't need to be disclosed.
That is correct. The case is called Dickus versus the City of Beaverton. That describes just what you said, Anno. Anyway, let's go to the next concept. Bias. Inability to make a decision solely based on the evidence and the criteria. And then he gives you some examples of where this could come up. Personal beliefs, strongly held that no amount of evidence is likely to overcome. So maybe that would be analogous to someone's up in circuit court. It's a death penalty case, and one of the jurors said, no, I could never, it's a death penalty case, I could never vote for the death penalty. Well, that person probably will be removed because that would be considered a bias. Or personal stake in the outcome and so on. The way to handle this is at the beginning of the hearing, not halfway through or toward the end, but at the beginning, if you have a problem with bias, you can announce that, and then generally you would excuse yourself. But let me go over a couple of concepts. The law understands that everyone has their own peculiarity. Some of you are conservative, some are liberal, some look at things this way, some look at that way. I mean, we know that everybody's like that. And so most of the time, people are not going to be biased to the extent that they need to excuse themselves. But sometimes that will happen. But understand that you can have some sort of general feelings and so on. The issue is, can you take the facts, the decision criteria, and make a decision from that? So let me give you an example of where bias was found by the Land Use Board of Appeals, just so So you have some examples. And this does not happen very often. It gets raised all the time, and it seems like 99% of the time, Luba will say that's not enough, and so on. But there have been a few cases. One case was called Niederer versus City of Albany. And that actually came out in 2018. So it's a very fresh case. And I think the opinion was published, in fact, in 2019. But this had to do with City of Albany. They had a historic district. And the issue had to do with an applicant wanting to demolish 3 historic buildings that were sort of run down. And they had a committee kind of make an initial decision, and then it could go to the city council. Well, one of the city councilors did a blog, and basically he said that he was his blog said, I'm gonna bring this up at the next regular council meeting at 7:15. I have spoken to 2 other of the councilors, and the 3 of us are in agreement that the houses should be torn down. And he goes on like this. Well, you can't do this kind of stuff. This is exactly where you're going to get yourself in trouble. This is terrible. And you shouldn't be talking to other planning commission members, even if it's off the record, even if it's not a quorum. That's not a good idea. The idea is you kind of deliberate in your group, but you don't. So this wasn't good. You can have sort of a violation of open meetings law by sort of a serial discussion with the members, even if a quorum isn't there, and that's a Lane County case. So don't do that. There was another case out of Jacksonville where one of the city councilors signed a petition supporting a church. The issue was the siting of a church. He signed a petition, saying the church should be cited, and then there were some other communications where he just showed that he was the big advocate for this, and then he voted on it. You can't do that kind of a thing. So next slide, please.
Hey, Jared, before you go on, one quick question about bias, though. When do people most often assert that someone's been biased? Is it after a decision, or is it like during the meeting? Because I really don't recall that happening. People may think it, and that's different than conflict of interest and ex parte communication. But is there a simple answer to that?
Well, I think, and I think Matt maybe could help me with this a bit, but I think that generally it could be the subject of a raise it or waive it if someone had the knowledge and they should have raised it. Generally, the county would assert that. And so I think if someone's aware of these underlying facts and stuff, they should bring it up at the proceeding. Do you have a different opinion, Matt, on that?
No, I don't. I was just going to say that typically when the chair calls for members to disclose ex parte contact, bias, or conflict of interest, I think it is helpful to also ask anyone in the audience, any folks that are parties to the case, if they have any challenges to any commissioners sitting on this matter.
Yes.
And at that point, then I think, it's pretty clear. I mean, unless something crazy happens somewhere down the line in terms of some revelation or something, basically, if an individual commissioner is going to be challenged for bias, for example, a party needs to raise that during the course of the hearing.
Yeah, I like that. And we did that particularly in Curry County. That was just written into our procedure that we said, does anybody have any challenge? And you're right, that is a good way to do it. Okay, let's switch gears, because what we said that, there are these different things that we announce at the beginning of the meeting, and one of them is conflicts of interest, and that's different than bias. And conflicts of interest are found in Chapter 244 of the Oregon Revised Statutes. And the whole basis of it is that public officials are not to benefit by in a pecuniary sense, that is putting money in their pocket or avoiding money leaving their pocket. They're not to benefit that way, by virtue of their status. You can, like, if you're an employee, you can receive your paycheck, but you can't get any special favors. And let's make sure you understand this, planning commission members. You are public officials. Even though you're not employed by the county, you are a volunteer, which we appreciate. And that means that you're subject to the conflicts of interest rules. And so there are two types of conflicts: actual conflicts and potential conflicts. An actual conflict is one that would occur as a result of the decision. So it would occur, it will occur. You're going to benefit if you vote on this thing, and potential conflict is one that could occur. And we handle these in different ways. So next slide, please.
Got a question for you, Michael. How is a conflict of interest different from a bias if they both have to do with personal gain, financial gain?
No, well, bias may not have to do with gain. Conflict of interest must necessarily have to do with gain or avoidance of loss. But a bias could be that that you, as an example I gave, that you signed the petition advocating for that church to be cited in that one zone, and you did all the rallies for it, and now you're going to be making the decision. And so that would be considered a bias, and you may not get one penny out of it. Now,
Right, but
go ahead.
It says on, if I think on your slide, it talked about, having of a personal nature, I guess. And so seems like it would be, it can be a conflict of interest if it is definitely a financial gain, but it could also be a financial gain from a personal perspective. Let's say I have a piece of property that butts up against the property that they're having land use issues about, and it would lower the estimated cost of that property. In other words, I would lose money because building a pig farm next door is going to affect who might buy our property, and therefore that would be a loss of financial loss for me. Which would that fall into, do you think?
So what was your question? Which what?
Which one would you say this would qualify, or does it really need to be decided if it's a conflict of interest or a bias?
Okay, so you need to announce it. And
Well,
an example.
But there's also a really important distinction. I think, Jerry, you're going to get to this, between actual conflicts versus potential conflicts. And if it's an actual conflict, then you need to recuse yourself from participating in the decision. If it's a potential conflict, you need to disclose it, but you can still participate. So, and Jerry, you probably refine that to distinction between actual and potential.
Yeah, so your example is a good one. Most of the time, if there's an application and it's for development right next to your house, I would say in most of the cases you would have a conflict of interest.
Mm-hmm.
And you talked about maybe your property values would go down. If it's a fairly certain thing, then we would call that an actual conflict of interest. You would disclose it, and then you would leave. Like if we were meeting in the room, you would leave the hearing and you could go into the audience if you wanted to, or you could just leave. If it was a potential conflict, meaning, well, property values may go down, but maybe they won't go down, you could announce it and still participate. But,
So an example for bias rather than a conflict of interest would be if I objected to a pig farm anywhere in the general vicinity versus right next door.
and your point's well taken in that there could be some overlap on the concepts, but we're going to evaluate each of those separately. And let me say this to all the planning commission members. You don't need to feel bad if you have a conflict or a bias, okay? Because that happens. What's important though is that when those issues come up, you handle them appropriately, okay? And so generally before the hearing, it's good to ask yourself these kind of questions, like, am I going to have a conflict of interest? Am I biased because of this particular application? If you have questions about it, you can ask your counsel or ask staff, and that's not an ex-party contact. Okay?
I think that's really important, rather than all of us trying to become expert on that. Whenever you feel at all coming into one of these proceedings, if you're even thinking this is an issue, give us a call and we'll talk it through, and we can always run it up the food chain to our legal staff, and because I don't think you want to struggle with this, if it's
you don't want to. It's not a good. And here's the thing: if you do commit a violation of conflicts of law, the Ethics Commission handles that, and they can have a separate hearing. You can be fined. You don't want to go through that process because it's not worth it. And we're here to help. We're here to help. Okay. So next slide.
Could I ask a question about
Absolutely.
that? This is Dick Cutler. What kind of legal situation does it put the county in if a commissioner unwittingly does not follow the rules for conflict of interest? Is that something that can a good lawyer can come back after the county to change a decision or to do?
Well, conflicts of interest, if they happen in the circumstances we talked about, the county is not made a party. The public official is made a party. So you need to handle that appropriately. Now, it is possible that, especially if it relates to bias or something and it's not announced, there could be a defect in the decision. And that's something that we want to avoid. Remember what happens when we have a land use application in a hearing. There typically is a lot of flexibility in you, the planning commission, making a decision. It's not unusual that you could go either way and still have it based on substantial evidence. But where people who don't like the development or who are on the other side of the fence come in is they look for procedural defects. And remember, almost all of land use is procedure. It really is. It's procedure. So we don't want to give someone a basis for a technical violation that sets something aside. Matt, did you have something to say about that?
Well, I was just going to respond to Dick's question, I think was, excuse me, if a decision maker is found to have had bias or conflict of interest that wasn't disclosed, then the simple answer is yes, that can be grounds to reverse a decision that a commissioner participated in with an undisclosed conflict or bias.
Or more likely a remand.
So his behavior really can have a huge impact on an application.
That's true.
But they're not found personally liable, right? Is that what you're also getting at, Dick? Because I think the impact is much more on invalidating a decision than.
Well, no, it could be. Just bias is a separate matter. But if it is conflict of interest and it's not properly handled, then a complaint is filed, because it's a complaint-driven thing. If a complaint is filed with the Oregon Ethics Commission they will likely investigate it. And there, you know, there could be a penalty imposed, and it's a process in and of itself, and that process is directed to the individual public official. So that's my okay.
Thank you.
That underscores more than anything, because I served on the planning commission for over a dozen years and I never found myself really confronted with this, but just if you're wondering, just like I said a few minutes ago, if you're wondering at all, talk to us in advance. Don't try to figure it out by yourself. And I can't imagine that if you somehow find yourself bound up in some kind of ethics complaint, the fact that you conferred with your legal team and your county councils and everything like that just seemed to really insulate you from any issues that could even theoretically come up. But I hope that's not a stretch to say that, Jerry, because it just seems so common sense to me that would be the case.
It could be raised. It could be raised. Okay. Now, what about this joke? Okay, next. Okay, so the general rule based on Pisano is fairness. Everybody gets to present the evidence. Everybody gets to see all the evidence. Everybody gets to rebut the evidence, and decision makers all use the same evidence. That relates to the ex parte concept. Next. I think up to 29. Okay. Remember, when the hearing closes, there'll be a time when no more testimony and no more evidence, including the physical documents, can be introduced. But the tricky part is that before the closure, someone under ORS 197-763 can ask one of two things. They can ask to continue the hearing, or they can ask to leave the record open. Close the hearing, but leave the record open. And we need to be aware of that, and because that is a right. Next. So typically the way we like to do this is if someone wants the record to be continued to see, we have the choice. We usually like to say, we'll do it by leaving the record open, because if you continue the hearing, it's more complicated and it could result in lots of extensions, more extensions. And remember, we need to either get the hearing done in 150 days or 120 days, depending upon the facts. And that includes all appeals to the Board of Commissioners. So typically, we'll keep the record open, and then so it's open for 7 days, open for another 7 days to rebut what's brought up there, and then the 7 days is for argument. That's what the 777 means. Okay, next.
Sorry, I was asleep at the mute switch there. Thanks, Jerry. So Jerry's kind of walked you through the hearing process and sort of how you would arrive at a point where the record is complete and the hearing is done. And so, and that's all kind of very, very prescribed procedure to get there. Now, the bad news is that once you're done with that, then the easy part's over and you actually have to make a decision. So, but the decision-making process is, again, it's all about these applicable criteria from the land use code, and it's all about evaluating the evidence in relation to those criteria. So, and at that point, as a commission, you really essentially have sort of four possible avenues. You either approve the application if it's judged to meet all of the approval criteria. You can approve an application subject to specified conditions, and generally those conditions need to be tailored in a way that they're very specific to achieving compliance with one or more of the approval criteria. If the application is judged to not meet any one of what is typically usually an array of approval criteria, then the application is denied. Or the final option is to continue the review, which is always an option if the commission feels like they need to gather more evidence or they need to hear from other people on perhaps an issue that got raised during the course of the hearing. So that's always subject to our time limits. So that's one to be careful about in terms of conferring with your staff and making sure we know where we are in the calendar. Next slide, please, Josh. So again, evidence in the record is the basis for your decision. And essentially, it's, again, this is a fact-finding exercise. It's matching up evidence in the record against the approval criteria to see how those stack up. Not supposed to be based on decision makers' personal values or opinions. I mean, we all have biases, and we bring those to, that's probably not the right word. We all have opinions and values, and we bring those to the decision-making process, and that's a good thing. We want that on the Planning Commission. That's why y'all got appointed to the Planning Commission. But those opinions need to express themselves through your evaluation of evidence and criteria. It's also contrary to what you may hear from people in the course of sometimes in the public hearings, not a vote. This is not a democratic process. We don't count hands. We certainly take into account people's opinions, but really those opinions need to be expressed in a way that addresses the applicable criteria from the code that we're judging these applications on. Next slide, please. So here's, Jerry touched on this earlier, and this is always, I think, a challenging thing for decision makers. I know it is for me when you know, I was in the business of evaluating these applications on a day-to-day basis. You're going to often be presented with conflicting evidence. You're going to have opinions expressed by people that, well, this project is going to have this impact on us or our neighborhood or our property. And on the other side, you're going to have evidence from an applicant that says, well, but we have taken steps to mitigate all those impacts by doing X, Y, and Z. And so that's an example where you have conflicting evidence. And, you know, the bottom line with conflicting evidence is it sort of goes back to this substantial evidence rule. It's evidence that a reasonable person would rely upon. And so as a decision maker, that's essentially where your judgment comes in evaluating that evidence. And you're not necessarily bound by any one side or the other. It's sort of a reasonableness test that you have to do to weigh that evidence, and you can reasonably decide you're gonna rely on one segment of that conflicting evidence to base your decision on. There's a kind of an obscure rule under RS 215, which probably won't, hopefully you won't ever have to come into play. Your staff will intercept this before it happens, but there's a rule known as the goalpost rule, which basically says that an application gets judged by the criteria that are in effect at the time it is filed. So in the unlikely event during the pendency of an application, the rules or the code requirements should change during that time, that new stuff won't apply. It's only what was in effect at the time the application came through the door. So and then finally, of course, we have the findings requirement. Decision has to be based on findings of fact. Next slide, please, Josh.
Matt, you
I
may
have a
be
question on that.
Yeah, sure. Questions, please.
So you said it was the time the application come in the door. Was that the day it was filed or the day that the staff approved it as a completed applicant?
It would be the former. Assuming it eventually becomes a complete application, it would be based on the standards in effect of the day it came through the door.
Okay, thank you.
And I think from a staff perspective, I was worried at first when you started talking about it, Matt, like, well, I hope we catch it, but our rules don't change very often. So this is right, Matt, that's going to be very easy. We'll know that.
Yeah,
for sure. That's going to really be striking to us, that we have an application that's in process and we've gone through a legislative plan amendment. That's like, we won't miss that. I'm really confident about that. You may miss a lot of other stuff, but we're not going to miss that.
All right, next slide, please, Josh. So talk for just a minute about findings of fact. So findings in really simple terms, there's all sorts of trappings around findings, and there's sort of we've developed a kind of a high art form in how these findings get constructed and drafted in land use decisions. But in really simple terms, findings are simply an explanation for the rationale that the decision makers, that you as decision makers employed in reaching your decision. The rationale being explaining the evidence that was relied upon, and explaining how that led to your conclusions regarding the compliance or lack thereof with the applicable criteria. So quasi-judicial decisions, of course, have to be supported by findings. Usually that's a pretty rigorous and detailed set of findings. Legislative decisions may, and generally we would encourage them to be supported by findings, but it's not going to be the same as a quasi-judicial decision because it's not really a fact-finding exercise. It's really just an expression of policy. So an explanation for the rationale for the policy choices that are made when a legislative decision is made would typically be the kinds of findings that you would see. Findings usually come after the hearing and record close, so usually there's an oral decision by the Planning Commission, and that decision would direct the preparation of final written findings that would come back to the Commission for approval. In some cases, a staff report can be incorporated as findings of fact, and generally with an approval for an applicant that is represented, we would direct them to prepare the findings for an approval. And there's a whole bunch of reasons for that in terms of how they get defended on appeal and that sort of thing. But that's the normal custom. So very, very much like a courtroom proceeding where the prevailing parties essentially draft the findings in order. Next slide, please. So this is what LUBA says about findings. And so again, this is sort of a very kind of linear and kind of sort of step-by-step logic approach. Findings, they identify the relevant approval standards. They establish what facts in the record were relied upon by the decision maker. And then they explain how those facts lead to the conclusion that the application either complies with or fails to comply with the required approval standards. Next slide. So there is a...
Before you go past it, so
yeah.
In developing the findings, I just have a quick question of you, but because I think it's so important for everyone to hear this. As from a staff perspective, that's why I think the deliberations are so important, because when you're talking, after you've heard a lot of the evidence and now you're in your deliberations, when you sort of go back and forth with your colleagues on the Planning Commission about what you're feeling about what you heard, I know from my perspective as a staff who's possibly going to be asked to write the findings, that's terribly important for me to hear that and to take notes and for you to articulate why as you're talking to your colleagues during deliberations about what's on your mind. So, because and then that very often becomes, especially if the applicant isn't developing the findings from a staff perspective, we really need to understand what you're thinking so we can create draft findings that come back to you and you go, yes, that's what we were doing. Thanks, Matt, for letting me put that in there. But
sure. So there is a process under Oregon law that allows certain kinds of quasi-judicial decisions to be made without a hearing. And so essentially those are what we would typically call administrative decisions that are made by the staff. And that's generally kind of the more routine stuff, conditional use permits, for example, occasionally, variance application, minor land partitions, stuff that is of a fairly routine nature, but they're still discretionary decisions. They involve the exercise of discretion. So the way that works is the staff can make initial decisions on those without hearing, but the decision has to be noticed to the same parties that would be entitled to notice if there were a hearing. So surrounding property owners, parties to the application, get a notice of the decision by staff. And then those parties have an opportunity to appeal that decision if they want to take it to a public hearing. So basically, the notice without a hearing, the basic procedural requirement is there has to be a notice and an opportunity for a hearing before those decisions can become final. So typically, and then the other thing that's important to know about a decision that is made without a hearing, if it does get appealed, and those are decisions that those appeals then would come in front of you as the planning commission. What happens at that point is that hearing is what's considered a de novo hearing. So another one of our $10 Latin phrases. My Latin's a little rusty, but it's something like from the beginning or from the start is what de novo means. And so essentially what that means in practical terms is a decision that was made without a hearing that gets appealed and comes in front of you as the decision maker is subject to basically a brand new hearing. So it's a wide open field. Any parties can introduce any new or additional evidence or anything that would ordinarily happen in a brand new hearing process. So basically starting from scratch at that point. So
Matt, with a decision with no hearing, are the time frames pretty much the same as with a hearing?
You mean in terms of the deadlines for decision making?
Yes.
They are. So that's always kind of one of the wild cards with making a decision without a hearing, is that in the event that they do get appealed, that extends the required time to try to get the decision in place, but we don't get any extra time under the statute to do that. So you typically, I'm going to probably maybe be speaking out of school here a little bit, but ordinarily, your staff is going to identify those decisions that if they see something that has a very high likelihood that it's going to be appealed, they know in their judgment there's issues with these applications. They would typically not make a decision without a hearing at that point, if for no other reason than the time required to get things to a hearing. They just send them straight up to the planning commission. So you're going to see stuff like that coming in front of you.
Yeah, Scarlett, under our code, it invests in the director of the department that call to make. We can do it a conditional use administratively, but the code literally has language. If it's more than if a highly consequential, more than routine matter, then it gives the discretion to the director of the department to take it up to the planning commission. And I want to echo what Matt just said. He was a speak out attorney, got it just right. Our standard for that is, if we're even asking ourselves that question, that this could become a big deal and there's a lot of people dug in and it might get appealed, that's our answer, that it's going to you guys. That we usually at that point, if we're even beginning to have that conversation, we're taking it to you.
All right, next slide, Josh. Very, very good, Jerry. The woolly mammoth whistle. I like it. All right, your turn, Jerry. Tell us about appeals.
Okay. So due process means that there is a right to appeal. And so we're primarily interested here in you as a planning commission. So you will make a call, and that can be appealed to the governing body, which is the Board of Commissioners. And if someone is not satisfied with the decision of the Board of Commissioners and they have standing, they can appeal to the Land Use Board of Appeals. You have to file a notice of intent to appeal with LUBA within 21 days of the date of the decision. There's some rules, if they didn't get noticed, we don't need to get into those. But, and I could round this out by saying from the Land Use Board of Appeals, if someone isn't satisfied there, they could go to the Court of Appeals. And ultimately, a few cases and not many find their way to the Oregon Supreme Court. Okay, next, please. So standing means that someone has the right to advance a proceeding to the next level. And generally it requires that you appear locally. So in other words, you need to have submitted something in writing or testified orally, generally, to have standing. And then this talks about filing notice of intent to appeal and so on. But generally, standing with us generally means that you participated in a proceeding. Next slide. So LUBA has 3 choices when matters come before LUBA: to affirm, to reverse, or remand. The most common thing that they do is to remand. Frequently, are defects in the findings. Findings are inadequate. That's a very typical thing. Sometimes you'll get a case affirmed, and we've had some recently. We've had some good luck on that. Rarely is the case reversed by LUBA. LUBA will only reverse if there's no way, for instance, that something can be approved and you approved it. There's just no way. You can't get there. Okay, next slide.
So what does LUBA stand for?
Land Use Board of Appeals.
Okay.
So
Yeah,
it's a
land use
special,
board.
it's a special court just to do Oregon land use because it's so specialized.
I just wasn't familiar with the terminology.
Thank you.
Yeah, a lot of terminology here. And by the way, don't be afraid to ask questions whenever. The staff and council are here to help. And
during, especially, Jerry, I want to echo, that's so important. During hearings too, stop and ask us. You know, don't, if you're lost or you're wondering something, I think it's really important to tap into us during a hearing too.
yeah, that's quite fine. It's better to do that than,
Oh, yeah.
not be sure of yourself and do something that maybe you're not happy with later. So,
Right, Can I say something right here?
Please.
Yeah.
As far as asking questions and participating in the hearing, I want folks to be really careful about asking questions and to direct, especially during the hearing process, your questions to the staff. Do not direct your questions to the audience, or not you might have a question for the person who is giving testimony on one side or another, but out of respect for the whole process, you need to address just that. And if there's a question addressing the person that's giving their evidence or the staff, but and look to the chair to get the attention before speaking out, because there's sometimes other things going on at the same time. So just really be respectful of that. And it's a lot of times it's a good idea to wait until all the evidence of the person, one side or the other lawyer, is done presenting before asking your questions instead of interrupting their testimony, especially with, I'm gonna make an appeal to our general audience. Just remember that these people coming are very upset, usually, and this is probably the first time they've ever participated in such a thing, and they don't know the rules, and they get caught up in the issue and things like that. And it's hard sometimes being where we are and seeing and watching this and not responding to it. And it's best to try not, poker face and ask respectful questions when they're done talking, and speaking, just as a general rule.
I think thank you, Andrew. That is so important. And I was on the planning commission for years, and in the last year or two, there were some times where things got too informal. And all of a sudden it was like, it became, open season, questions coming from the audience, planning commissioners addressing people in the audience. And there's such a human tendency to someone asks you a question, but Andrew, thank you for saying this, because once we start to act like that, then the audience will, because they're emotionally involved, they will leap into the fray, and then we have a mess. And so I really appreciate you saying that. And one of the reasons you were agreeing to take on the role of chair here was because we needed to tighten up our procedures on that front. That's a really important thing. Thank you.
Right, we want to keep our deliberations and the deliberation part, keep your questions to the, keep things in the meeting order. And if people want to start to yell out things, they will be directed to wait for whoever's there and to come up and sign in and testify. That's what they need to do. They can't just shout from the audience. They need to actually get on the record. And Joshua gets their name and everything, so it's very important.
Andrew, you know this already, but in this day and age, everybody seems to want to have a meeting facilitator, and I'm old enough to remember when a chairman knew how to use a gavel, and all of a sudden, if there's stuff happening in the audience where people are beginning to just lose it and thinking they can start standing up and making statements, that's time for the gavel to come down to him. And as planning commissioners and the staff, we can't feed into that. That's just so important. So thank you for that. Terry.
So that concludes the presentation. We do have, we can talk briefly, Matt and I, about how the procedure will be slightly modified because of COVID and what we're doing. We could go over that if you'd like. One thing I'd like for all the planning commission members to remember, and this relates to our concepts of ex parte contacts and so on, you're going to have a couple weeks before the proceeding, and be circumspect about the whole thing. You don't want to talk to somebody who might be a party. You want to just, be very professional about this and not have any ex parte contacts that you could avoid. Matt, should we talk about the proceedings there for this meeting on the 23rd?
Yeah, sure. Let's do that.
Okay. Matt primarily has done a lot of work on this, but we all worked on it through quite a few meetings. I'll generally go over the concept, and I think I don't want to bury us too much in the procedure at this point because there will be some variables and so on. But remember, this is the important aspect of our hearing. It will be without live witnesses, and so it's going to be different. It's going to be run like today somewhat. It'll be this type of a thing, and people will not be able to ask questions and directly participate at the time of the hearing. They will be able to listen. This will be live streamed, but they will not, and that will comply with the law, but they will not be able to directly participate. So what will happen? The chair is going to open the meeting, and the staff is going to do the staff report just like normal. So that part is like normal. But we have told the applicant that they can do a recorded presentation if they'd like, and I think they're going to. Okay, recorded presentation or written statement. If it's a written statement, it'll be read into the record. If it's a recorded presentation, it'll be played into the record.
But Jerry, the point just needs to be proceeded, doesn't it, with the point that they've already submitted their application with a lot of their arguments in it, right?
Yes.
So, and you've got that as part of your packet.
Yes.
So we're talking about the hearing. So, and now we're talking about the hearing itself, which usually they would have made another presentation in person, but because of these COVID regulations, now that's why we're doing this technology and the new procedure that Jerry's talking about.
Yeah, that's right. And so they'll probably give us a recorded presentation. It'll just get played just in this venue that we're doing right now. So, and then when that's done, staff is going to go over what we have in the record. So people will be invited to submit materials to the record. It's going to be encouraged that we get them before the hearing starts, although it's not necessarily required. And we will list what we have received. We're not going to read everything, but we're going to list what we have so people who are interested will know what is in the record. I think our chair will poll the individual commissioners to see if they have any questions that need to be directed to the parties. And so that will be transcribed and we will get that out. You know, for instance, there might be 3 or 4 questions to the applicant. And that will be directed to the applicant. This E is motion to leave the record open for 7 days. So we're going to make a motion to leave the record open for 7 days. We're going to ask the planning commission to do that.
But Chair, when the chair asks, or when the planning commission asks questions of the applicant, they're not responding live like they would in a normal hearing. This is going to be like a correspondence course. It's going to be like a written hearing, except for the part you're about to hear soon.
That's right. That's right. And so the way that'll be handled is we're going to ask the planning commission to initially leave the record open for 7 days, and included in the motion will be that rebuttal, testimony, responses to questions, and any request to hold the record open beyond the initial 7-day period have to be received within the 7-day open record period. And a statement that within the initial 7-day open record period, any party may request to hold the record open. If such request is received, the record will remain open to all the parties for an additional 7 days. And so we have stages for after the initial 7-day period. We're going to be distributing and posting copies of the written testimony and responses. Everybody has to know what the heck is in the record. And as Anno indicated, this is a little tricky, but we're going to do that. If there's no request to hold the record open beyond that initial 7-day period, we're going to close the record except for the applicant's final written arguments. We're going to notify applicants of the 7-day period to submit their final written arguments. But if we do get another request to hold the record open, then we're going to notify the parties to that effect. So it's similar. It could go about 3 rounds in that way. But eventually what will happen is that the record will be closed. There will be final written argument sent. There'll be a 7-day period to do that. There's going to be ongoing communication. You know, the record is now closed and so on and so forth. And we're going to have a time. We're going to have to get back together, the planning commission, for deliberations, just like you would in an ordinary proceeding. And we'll get out notification of the date and time of reconvening, and people can observe you deliberating. And then, of course, you're going to make an oral decision, and we will need to reconvene again for purposes of adopting a final order. So there is a lot here. This is going to be a very difficult process. So I'm asking that all the planning commission members work as well as you can with our chair, and we're going to try to encourage this to move along because we're under a 150-day timeline, and we expect an appeal. We have to do the due process that we have to do, but we want to move this along. And whether it's approved or denied, we expect that there likely will be an appeal. That is all included within the 150 days. So anyway, I kind of went through it quickly, and Matt did the lion's share of the work on this. Matt, did you have any questions or comments?
No, I don't think I have anything to add at this point, Jerry.
If I understand it, Jerry, let me explain. Let me just say this very quick. So we're anticipating with the application coming up on the 23rd, there'll be that first night that we all come together, And then we know the record's gonna be kept, I mean, the way this works out, we don't have to, we know no decision's gonna be made on the 23rd. And then, so 7, 7, and 7, right? Then we get this, and then there'll be a second time that you're gonna be asked to come together in this format to deliberate live, which is the exchanging of information with each other, right? And then at the end of that deliberation, you're going to make a decision. But then and then depending on what your decision is, either the applicant's gonna be developing the findings, or or the staff will be developing the findings, and then you'll come together for a third time to approve, to more or less, and this is what we do typically, is to approve the findings. So there'll be 3 of these, there'll be 3 times when you're actually brought together to deal with this upcoming matter. Is that
That's
right?
correct. Yeah, that's correct. But in the meantime, there will be a lot of homework for all the planning commission members to do. There's going to be a lot of submittals. You need to read the staff report. You'll need to read the materials that are submitted. You'll need to read the final argument and digest it and be prepared. So we appreciate your work. This is going to be, there'll be a lot to this. And it'll be a good experience for future hearings as well.
Okay, I've got a little bit of a question, of course. I always have questions. So, sorry about that.
No, great.
After the initial presentation that they give, the recorded thing that you're expecting, the commissioners can orally state some questions if we think of any right then and there. And
First
then
night. That's the first night we're talking about, yeah.
first night, but there will be no answers because from them responding at all. But we will get maybe some written, that day goes away, they may respond. And if there is general public or opponents to this whole process, they will also be doing things in writing that we will be getting during this period of time before our deliberations. Is that correct?
That's correct.
But you're right, Anna. Normally on that first night, under our traditional hearings that are live in person, the applicant would be responding to questions from the staff or from the staff but especially the planning commission that same night. So they're gonna be listening, and then we're gonna be putting them in writing.
Where does it come in where sometimes we have questions to the opponents? Where does that play out in this process? If someone brings up something in opposition and we want some clarification, where does that play in here?
Well, I would have one possible response. I think that you may have some opponents submitted material before the first hearing, and you could have questions that you could parcel out from those written materials that you received before the first hearing. And hopefully that's when it would come up. As I say, we want to expedite as much as possible. Look, we gave you, the way I look at it, and Matt or Anno can correct me, but we're giving you what we think is the likely pathway to get through this. It is quite possible that someone will raise some issue or do something that causes us to pause, reflect, and maybe do something slightly different. We think that this meets due process. We think that this complies with the new Oregon law under COVID. I think we're happy about it, but we don't know what possible glitches could come up. But I would say this to the Planning Commission members: if you have questions, it would be good to do your homework and review both the proponent's material and the opponent's material before the first hearing, and write out your questions then. That would be the best thing to do.
Jerry, if
Yes.
I'm going to play devil's advocate here and say, we're still having problems with mail delivery. And if someone who opposes this doesn't have a way to electronically send it to us, Or are we going to offer any options beyond the 7 days?
Well, we could see if someone complains, but they could mail correspondence. They could drop off correspondence, as far as I'm concerned.
Yeah, I was just talking about mailing in particular.
You know, I don't know. You could listen. I would like to have something like the 777 that we have, for the reason that we will be hard pressed to get this done before the 150 days. And let me tell you what happens if we don't get this done on time. If we don't get this done on time, the applicant has the option of filing a writ of mandamus, and that's a very bad thing for us. They can be entitled to attorney's fees, and they have the circuit court, which doesn't know anything about land use in theory, make the decision. And we don't want the circuit court to make a decision in a field that, you know, they handle criminal and civil, and they don't do land use. And so we don't want it to go there. So I don't know, maybe someone else could chime in, but that's what I think.
Let me try to respond with that. This 7 and 7 and 7 thing, that part is pretty typical of what we have. If you're not participating in a land use hearing, if you don't know about it in advance and you want to try to plug in halfway through, you better get up to speed awful quick and do it. So, you know, and I think this is just sort of the, you know, there's a limit to how much public involvement you can have in these proceedings. And it's really, there's a burden on the public to be engaged. And if you're going to get engaged, and be serious about it. But I like your question, because I really think it's going to be interesting to see how we feel about how different, well, at least for those of us that have been through the traditional process many times, whether we like this new process or we think it's horrible. And I'm really interested, after this is over the first time, to see how the public reacts to it. I mean, who's going to like this new approach, or who's going to hate this new approach, or what? But again, it's the exigencies. It's the exigencies. Late in the day, we just have no choice because of this COVID thing. We've sort of delayed having hearings and put some people off because we all thought COVID was going to be over sooner too. But now with of course this next application, and obviously this is going to go on for a while, we really knew we had to dig down, and the legislature had to be able to create this new procedure for us to be able to do this. So I think we're going to be legally sufficient, of course, Jerry, right? As long as we slavishly apply ourselves to that statute, these timelines, and just stay after it.
I agree with you.
I think too that we need to pound it into people's heads when we first start this time. This isn't, you know, normally we wouldn't be having that kind of discussion at the beginning of a hearing. It would be a different situation, but we need to really emphasize to the people who are there that there isn't, that basically we don't have an option, and that they need to make sure that they meet the deadlines if they want to, you know, be seriously considered. So that would be my toss up there as part of our initial, you know, greeting and notices and so forth that we give them before we really start the hearing. Emphasize to them that this is a new process and really have to be on top of it, and we aren't going to be able to, you know, allow less flexibility and something like that.
Well, Shailen, I'll one up you, or at least contribute more friendly amendment to what you just said, which was I of course agree with, is that once the community begins to understand what's on the table, you know, it's going to be very interesting to see how many people really, you know, are going to care deeply about this issue and want to be engaged. And so this is potentially an issue that would be a very high profile issue in our community anyway, and it's a heck of a one to start with, to have this sort of new COVID procedure so, you know, we're just going to have to, this is going to be a very interesting experience, I think, how this happened and how it doesn't happen, and how people react to it.
Yeah, I think so too. And the fact is that everybody doesn't have access to the, to having some kind of a computer generated issues, or they can follow, and not having the option to come in person is probably going to set some people off.
Well, you know, it is what it is. I mean, we just do not have a choice, right? It's COVID, and it's.
And it is, yeah.
You know, this is, the irony is that a counter argument could be made that what we're doing right now and the ability for people to plug into this and having it live streamed is already much more public friendly than our in-person meetings over in the courthouse that you actually have to go, you know, participate in. But look, we didn't make this process, right? This is a process that's been handed to us in good faith under the crazy circumstances of COVID, and we're just, you know, trust me, we've spent a lot of time. I really thank Matt and Jerry and Josh and John. We've all had to spend a lot of time wrapping our arms around, you know, what this new process looks like, learning this new process so we could staff it properly. And the amount of, in this case, the amount of time and energy that's gone into the staff report has been, you know, a tremendous amount of effort. So we'll just do our best. But your points are very well taken. I think every opportunity to communicate that this is different and explain those rules to people, we should seize every one of those opportunities.
Misty, did you have something you want to say?
So, yeah, I just want to say, can we, understanding that this is going to take multiple meetings, can we just have a list of reserved dates that the 23rd is one, the next one will be the whatever day, the next one will be the whatever day and whatever day, so that we kind of have an idea, even if it doesn't go every single one of those times, to have a projected schedule. Does that make sense?
We call that sort of calendaring the days, right, Matt and Jerry and John? I don't know that we've done that precisely. We've certainly done our own trying to reverse engineer what are the drop dead dates, but right there's, we should be able to do that.
Yeah.
What the
okay.
hearing date would be. So when is
Yeah.
this group going to meet after the 23rd, potentially? I mean, we have holidays, we have a lot of people here getting involved. We need to schedule out.
Is that like 2 or 3 weeks looking ahead right now after the 23rd?
Well, the problem is we don't know how many times people are going to ask to have the record left open. But I think that it's a good idea. I like what Missy has said, and I think that we should have some possible dates out there, but we can't lock it down completely until we go through the process. That's the way I look at it.
Oh, I agree. I want to mark my schedule off so that I'm always available on the potential days.
Yeah.
Right.
So
We'll try to get some potential dates, but as soon as, God knows, as soon as we really have we know what that next lockdown date is, you're going to be the first to know.
Okay.
So as the new kid on the block, the question I have is, so I've got a copy of the staff report. Is there any point in time when when we get together just to discuss it amongst ourselves without the public right there?
No.
Oh,
Absolutely not. That's the whole.
Unless you want to end up on the front page of the Oregonian.
Right.
and not a flattering way.
We never meet outside of a public hearing.
Yeah.
No.
so questions that I might
Not only
have.
don't do it, it's discouraged. It's not legal.
So if you have questions when you receive the packet, all the pieces before the 23rd, you yourself can call the office and talk to Anno, and he'll direct you either to himself or other staff to answer some of those questions. But we, as the commissioners, don't talk to each other until we reach the deliberation point of the whole hearing, COVID or not.
Okay.
That's the only point that we really talk to each other about different opinions about
Scarlett, I'm really glad you asked that question so you understand that.
Well, and I can appreciate it. I went through it and yeah, I've got a few questions. So
And we'll talk. we'll make arrangements. In fact, we would welcome that. It is a big staff. It's a complicated staff report. There's a lot of stuff in there. And yes, but we're at your disposal to do that. Just don't do it with your fellow commissioners until it's time in the formal context to do it, please.
You should have started on a good old cell tower issue or something, you know? We shouldn't start with something so big. We should have started with our regular.
Andrew, you understand this, just like with our planning department, we do not go out and make business. Business
That's
comes
right.
to us.
Please don't, yeah.
And GP wanted, they were very anxious. I don't think they were deterred by this new process. I think they actually embraced the idea they get to do it this way. And I think their corporate headquarters want some kind of an answer. So by God, we had to knuckle down and figure out how to do this and and there's some other stuff backed up too. But
Yeah.
Andrew, my
Thank you
first time on the planning commission was Mariners Village, and that was a really big rock and roll, and that was all one night.
I know.
Packed room, and when I got home that night, I stared at the ceiling and I said, "What the hell did I get myself involved in here?" That was like my toughest night on all those years on the planning commission. Was my first night.
Yeah.
And I was this deciding vote, and it's the only vote I ever made that I regretted. Now the development never happened, so it didn't matter. But yikes, here I am, all these years later, still Twitter-pated.
Right. Are there any other questions then right now that we can answer?
I have one,
Yes.
and only one. We're prevented from discussing among ourselves as commissioners any event until the deliberations, as you mentioned. But what about an application like we saw down at Beaver Creek or Ona Beach that kept coming back and going through extensive planning? Does that apply to an application like that? Is there a difference, or maybe no?
Well, you mean talking about it now after it's been decided, or?
No, during the process, if set up a hypothetical, if we're going to go through or we have the opportunity to look at a new park addition, a state park addition, and it keeps coming back, and we are really not supposed to discuss that with any of the other commissions off the record.
That is correct. It'd all be on the record.
Oh, this is all the way across the board. There are no exceptions. Okay. Well, thank you.
And that's part of, it goes back to the very beginning of the little workshop that we had tonight with that ex parte communications and things like that. It's all about transparency. It's all about the public saying, wait a minute, we don't want a bunch of you guys going off to some coffee shop somewhere like the good old boys and deciding so that there are, in other words, real meetings outside of this meeting. That's why it's so strict on that front. And so when you get into those quasi-judicial, because remember, even Brian Booth State Park, Dick, was a quasi-judicial matter. They were asking for a zone change at the end of the day.
Okay, sure.
We sort of had, we were locked into that quasi-judicial, lockstep with an applicant who has all of these rights compared to now remember we talked about legislative stuff. That's far more open-ended. Ex parte stuff doesn't apply. And I think you'll always know, because we will tell you, ladies and gentlemen of the commission, tonight, this is a quasi-judicial matter, and it'll be in the staff report. Again, just you won't have to wonder which one of these things we're in. We'll make sure that you'll know. But I'm glad you asked that question. That's really important.
I have another one, and that deals with ex parte. I remember when I first came to the commission, one of them said that he had been on the commission for quite a while, and he had never visited one of the sites that comes up that we're going to be questioned about. I don't know if he meant that he'd never discussed it with anybody, or if he'd never physically driven out and looked at the application. Does ex parte apply to your behavior? I mean, I came in with the notion that the more knowledge I could gather for myself ahead of time, in looking at a property that we were going to be confronted with. But maybe I was wrong in going out and looking at these things. Maybe, does that mean that only the staff that were prohibited from visiting properties to take a look-see before we have to hear the folks make the presentation?
Well, this is Jerry, and remember, the rule is that a decision is made on the record. Okay, it's made on the record. So if you make independent investigations, you're gaining knowledge not in the record. And so really, the goal isn't necessarily to have the most knowledge. The goal is to make a fair and impartial decision based on what's in the record. Now, if you have a situation where it is important and the Planning Commission as a whole feels it's important to do a site visit, that can be organized and that can be arranged and everyone can go out and, with the public being able to be there too and that kind of a thing. That's a possibility. But don't do a site visit on your own because that can be in the nature of an ex parte contact.
Now, Dick, is that completely foolproof? No, because look, we live in this community and some of these places we already know without having to go out and visit, right? And of course we're bringing our knowledge of oh yeah, it's let's just bring up Salishan for a minute, right? That there were a number of, we just had in the last year or so some major stuff going on with Salishan. Now everybody, Terry Bugenhagen lives in Salishan and then all of us had been to Salishan at one point or another. So, but I think once we're in this quasi judicial mode, then all of these things start to track us in certain patterns, and yes, it may seem counterintuitive, but that's not a welcome thing to go out there and look at it for yourself.
What about, you talk about Salishan. I live in Salishan Hills. So when when Salishan, the lodge, decided that they wanted to make these changes, they invited all of the residents in both Salishan and Salishan Hills to come to a presentation of what they were going to do or what they were going to try to do to bring the lodge back as they were placing it. Let's say that I went to that before I knew that was going to come to the Planning Commission for consideration. Perhaps it was, either I didn't know the information that that Jerry and Matt gave today, or I wasn't a member of the commission. So I go to it, and then I've seen all this information that they've provided. Does that fall into a bias or a conflict of interest? Or is that just a matter of same way it was in the newspaper, all of that kind of thing that, was known community-wide? Eve, where does that fall?
I think it falls more likely in ex parte contact of the three things you noticed. So the way to handle that is you announce it at the meeting, and then if someone has some questions of you or something, they can ask those, and under a procedure, I guess those would have to be in writing and so on, and you would respond. But sometimes you can't help those things, and if you have extra knowledge gained that way, I think that falls within the idea of ex parte contact.
So we could basically acknowledge that we have received this information, and then pretty much take it from there, as long as the information they gave it isn't prejudicial, I guess you'd say.
Well, I mean,
Disclose.
it could be. Go ahead, Matt.
Well, what I was going to say is the important thing about an ex parte contact of that type is that you disclose the information that you received so that everybody else that's participating in the proceeding has an opportunity to rebut that information. So and that's kind of the basic concept is everybody should be operating on the same information, and that should be known to all the parties.
Okay, thanks, Matt.
Okay, any other final questions after our 1 hour of fun?
It may not have been an hour, but boy, it was fun, wasn't it?
Very
Any more
informative.
Yes, yes. Thank you for pulling all this together as well. If there's no other questions, we have some planning commission concerns. Seeing none, we're ready to adjourn.
Yeah.
Okay, all right. See you all in a couple weeks. If you have
Thank you,
questions,
everybody.
go to staff. All right.
Thank you for participating, everybody. Really appreciate it.
Bye.
We're here for your questions.
Goodbye.
Bye.
Bye, thank you. Thanks, Josh. Thank you.
Thank you, John.